Welcome to Court of Protection Briefs, another blockbuster topic for this video, best interests. Every decision made on behalf of someone in the Court of Protection must be made in that person's best interests. That requirement extends to anyone outside the court exercising decision-making on behalf of someone without capacity to. It's all about best interests. That could imply an objective standard of the best thing in that situation or circumstance, but of course it's more complicated than that. Section 4 of the Mental Capacity Act sets out how that best interest should be arrived at. Decisions cannot be made on the basis of age, appearance, or assumptions based on any condition the individual might have. Think of the care cliché about a cup of tea. Does she take sugar? To which the answer is, why don't you ask her and she'll tell you? Well, I can't understand a word she says. Why don't you ask her to write it down? It's just a scribble. Why don't you try pictures? And so on and so on. Assumptions run deep and are difficult to shift. Many conditions and disabilities mask a rich internal life, and the law ensures we guard against assumptions that are all too easy and sometimes convenient to make. Everything that ought to be considered in making the decision needs to be taken into consideration, including the individual's past and present wishes and feelings. If someone has always had a fear of heights, always chosen to live on the ground floor, there's no reason to force them to live on the 10th floor just because, in the eyes of the law, they no longer have the capacity to decide for themselves. Beliefs and values must also be taken into account. If someone has been a lifelong vegetarian, they need to live somewhere that can accommodate that need based on a lifelong value. Consideration must also be given to whether they might regain capacity and when that might be. The court should be very careful about making radical decisions which limit the individual's ability to make their own decision once capacity is regained. The person concerned must be allowed to participate or be supported to participate in the decision. Just because they do not have the legal capacity to make the decision, if they have a view on the decision or factors involved, that must be taken into account. Not followed, but taken into account. Anyone close to P or nominated by P should be canvassed for their views. That includes someone who cares for P, their attorney or deputy, or anyone interested in P's welfare. They are likely to have a much greater and long-standing idea of what P wanted when they had capacity, and perhaps a better idea of what they want now that ability is compromised. Another requirement in Section 4 concerns medical treatment that might cause P's death. We'll look at that in the video about medical treatment. The test in Section 4 is a wide-ranging one, designed that way to allow the court flexibility for each case. Really, it just sets out a checklist to make sure that all relevant information must be taken into account when considering what someone's best interests are deemed to be. And there's no absolutes. No definitive right and wrong should someone live in one place rather than another. Both places will be able to deliver the care P needs, otherwise the court is unlikely to consider them at all. But which is more in tune with what P would have decided between if they still had the capacity to make the decision for themselves? An example. P is elderly and has dementia. He is no longer verbal. His wife G is his carer. It's a second marriage. P's adult children are critical of their stepmother but provide no care themselves. Care professionals note the adult children's antagonism towards G. G wants to sell up and move with P to be closer to her family several hours away. She is getting frailer and wants to be closer to her own support network and away from the antagonism. P and G co-own the house and will co-own the new house. Permission is sought to make the decision on behalf of P to sell the house, but P's family are having none of it. They want P to remain living near them in the current house. What is P's best interest in this case? The court is going to have to consider all views before deciding. In matters involving husband and wife, the court will be slow to find for someone who wants a different outcome to the spouse. But in matters involving a parent and child, even an adult child, the court is also keen to support that bond. An important factor when considering best interests is that it is generally restricted to options that are actually available. The court is only interested in real-world practical choices. They don't want to waste their time considering options that are simply pie in the sky. That's it for this Court of Protection Briefs video covering best interests in the Court of Protection. Subscribe or look out for the next video from Court of Protection Briefs.